Hello, I'm Kirsten Howe. I want to talk to you today about 3 estate planning documents that every adult over the age of 18 should have. The first is a general durable power of attorney, which is a document that allows the person that you've chosen, which we call your agent, could be a friend or a family member, to make legal and financial decisions for you and to take care of things for you, legal, financial, if you become incapacitated and can't manage things for yourself. The second document is an advanced healthcare directive. In an advanced healthcare directive, you name someone, again, your agent, who will be able to make medical decisions for you and take care of all of your medical matters, like getting your medical records transferred to a new doctor. In an advanced healthcare directive, you also give instructions and guidance to your agent on topics such as long-term care, disposition of your remains, organ donation, and much more. The third document is a HIPAA release or HIPAA waiver. We have federal and state laws that protect our private medical information. With a HIPAA release, you are authorizing your care providers to release your private medical information to your agent so that your agent will be able to review the records, have conversations with your doctors, and make good medical decisions for you. I know I said I was going to talk about 3 documents, and I already did, but I just can't help myself. I'm going to talk about a 4th, and that is a trust. Now, a trust is not something that everyone over the age of 18 needs. Young people who don't yet have a lot in the way of assets usually don't need a trust, but most adult Californians do. And a trust will also help your friends and family members and the people that you choose to help you if you should become incapacitated. If you don't have these documents, a judge will have to decide who is going to take over for you and make legal, financial, and medical decisions. That is called a conservatorship proceeding. Conservatorships take a long time and cost a lot of money. One thing you don't have if you become incapacitated is a lot of time. It's very important that someone you know and trust be able to step in very quickly to help you if you become incapacitated. That won't happen through the conservatorship process. What you probably have figured out by now is that estate planning is more than just planning for what happens after you die. Planning for your own incapacity is a very, very important part of estate planning. I am going to be hosting a live online webinar talking about everything you need to know about estate planning. During this live online event, we'll discuss not only the documents that we just talked about, everything you need to know about estate planning for death and incapacity, but also something that's very important and often overlooked, which is what do you do once you have an estate plan in place? What is the next step? You would be surprised how often we discover after someone has died that they didn't quite finish taking that next step. What I'm talking about is funding your trust. So we're going to talk about that in detail because it's very important and often overlooked. I won't be giving any legal advice during this presentation, but I will be telling you all kinds of information, very important information about estate planning, and also you will have a chance to ask your own questions. We know how easy it is to procrastinate when it comes to something like estate planning, but we are here to help you get unstuck and just get started. So I really hope to see you there.